Welcome to your LNTV. And this morning we are here on the grounds of the Temple of Justice, where earlier on this morning, maybe by 11 to 12 midday, we will converge in the chambers of the Supreme Court, where the final ruling of the Bill of Information filed by Councillor Fanati Kofa lawyers will be handed down today by the full bench. The Bill of Information filed by his lawyer, the intent of the Bill of Information filed by his lawyers was to have an interpretation of December 6th ruling that was given by the Supreme Court in the writ of prohibition that was filed by his lawyers earlier. And then after the ruling on December 6th, on December 12th, Fanati Kofa lawyers did file this Bill of Information, which was scheduled and then heard on March 26th, where legal arguments were entertained between both parties and then ruling was reserved. For now, we cannot speak directly for the court, but whatever emanates from the court will be the ruling that will be adhered to. And so we are here this morning, as I said, to actually hear the final ruling from the full bench of the Supreme Court concerning the Bill of Information that was earlier filed by lawyers representing Councillor Fanati Kofa.
But we can tell the audience what the lawyer is doing from Kofa and majority.
Well, for the lawyers representing Councillor Kofa, the lead lawyer is Councillor Arthur Johnson, and for the majority bloc, the lead lawyer is Councillor Barney Sherman. Like for both arguments that was heard last year, Councillor Barney Sherman of the majority bloc, there was one thing he maintained up to present on March 26th. He did tell the court that the Capitol building is a political ground, one. Two, separation of powers and interference was what he mentioned. And then Councillor Arthur Johnson did preach on behalf of his client that indeed he was removed illegally and that was not done constitutionally. And so both arguments were heard. They argued before the full bench and ruling was reserved. Normally when arguments are being heard the same day, there's no ruling that will come down for the same day. They have to give her time and postpone it to have their colleagues go into the ruling room, argue it, and then come up with a final ruling. Besides that, whenever a ruling is being carried out or will be handed down, what is done next is that a notice of assignment is being carried out or is being given out to both parties. But without the notice of assignment, people don't assume or presume that this will happen. And so this notice of assignment was given to both parties, and then it came out to the public from the clerk of the court. And so that's why we are here today, April 22, to receive the final ruling of the Bill of Information that was argued before the Supreme Court on March 26, 2025.
We are being listened this morning. What are the so far the grounds of the Temple of Justice?
Well, we have security here as usual. This is the front view of the Temple of Justice. We have the security from the Judiciary here wearing the khaki, and we have our Liberian National Police, some of whom are assigned here at the Capitol building, at the Temple of Justice rather. And then at the entrance facing Capitol bypass, we do have police officers also assigned there, and within the compound we have police officers on my left extreme that are assigned, and they are making sure things are put into order, and they don't want anything violent or chaotic to happen, not anything like action that will raise our bars. And so they are here putting things in place to have security matters and security functions be put in place. But what's going to happen is that we've been here for some time, and slowly we find people coming. Once the hearing is slated for 11, gradually you find people coming to the court. But I haven't seen any lawmaker around yet, and probably they will be coming later on, because this is a crucial ruling and people need to hear what the ruling will be all about based on the interpretation from the full bench of the Supreme Court. So as time goes by, you find people coming in and to come and sit and maybe wait for the time to listen to the ruling. As for now, there are several journalists on the grounds of the Temple of Justice who are here to cover this event.
Do you think both Councillor Kofa and the majority bloc member will be independent?
Probably yes, but sometimes when matter of such is happening or is on, normally you have lawyers representing them to receive the ruling. But sometimes there's no law that says that maybe the petitioner that we refer to as complainant cannot be present. If he wants to be present along with his legal team, Councillor Kofa might be here, or Councillor Barney Sherman might be here. Obviously, Councillor Barney Sherman should be here to receive the ruling, and Councillor Arthur Johnson, who has been around here for a couple of hours, is still on the ground. They are here to receive the ruling. But whatever the case is, that we saw on March 26, where they had a lot of the the colleagues from the House that came to witness it. Probably we expect to see some of them around today to receive the ruling, or better still, to listen to the ruling from the Supreme Court.
But you are there and cover several landmark cases. Why do you think that said this particular case the part of other cases that you have?
I think it borders around constitutionality, and that's the main thing. And people want to know because there are three separate branches of government, and so a lot of people want to hear from the judiciary that interprets the law. And so, as I said earlier, we cannot speak for the court, we cannot assume for the court, but this is a landmark case because people will feel that or think that probably it's happening this way and it shouldn't happen that way. In any given instance or circumstances, you always have people for pros and cons. And so once we have both sides that aren't going the same way, obviously, we have a lot of opinions emanating from that. And so because it came from the House and it has stalled so many things around, and some people believe that it still needed more questions or answers to that. That makes it important, as I said earlier, it borders around constitutionality. And so we are here for the court to interpret exactly what's going to happen in this bill of information that was filed as compared to the bill of prohibition that was filed earlier. So we are here today to hear from the full bench.
Thank you for anything before we leave.
Well, we are all Liberians, and we pray that the best come from the court, because the Supreme Court is the final arbiter of justice. Some people in our lay term will say from man to God, and some people will say it's the last bus stop. But we pray that there will be good results today, and that we Liberians will welcome whatever results are emanating from the Supreme Court, because this is our country. Liberia is all we have. Peace first and peace last, and so we want everything to become a peaceful around here as we await.
Thank you so much. So on that note, the pledge of
I believe the people of the Judicial for the Central Maybe Charles, the Happy International Medical Limited, is represented as the records. Present is Councilor Ibrahim Selassie.
assignment as dean and associate. Yes, Mr. Marshall?
Okay,
Sam C. John. Okay. And as heritage. Yes, Councilor. Yes, heritage. So did you go to dean? So what's the other way around? Which other dean is on the Marshall feature?
As indicated, the next receptionist should be the person assigned on behalf of the but there's an application from Dr. E. Judy Johnson.
So Marsha, you sure it was from Judy and Associate because we have on record here a letter from Councilor Silas Johnson from the Investor Rally law firm saying that they did that the wrong way to sign for the assignment. We are aware that she used to be a Judy and Associate, but she's at a different house than law firm is not. I mean, sir, it's not Judy and Associate. So you get what I'm saying?
That's okay.
It's with Dean and Associate. Where's Dean and Associate?
It is the same law firm, Dean and Associate is not much about it. So, Musa being left the law firm to change it to
We are unaware of that. We have only given notice on our consolidation of other ones. Between Dean and staff and this regard.
So, you know, it's the same office.
We can extend and establish that. That's why we're discussing it. Lawyers, counselors, you're also able to pay the report. You're found in the report for assignment. We come and hear a case that has been pending on the market from 2012 or 2015. The case is called, and you have more interest in it, I can use that phrase. You sit there and don't even have the office on the clerk in the marshal. By now, the party themselves should have been served, knowing that Dean and Associate but no more. And you know that what is the precedent of this court. If the lawyers cannot be found, and what that the party themselves. And I think taking it to Dean and Associate because of what is happening there is this law firm that's in the place office. And that there, that one of the lawyers was with Dean and Associate, but we have no record of Dean and Associate, and that's regarding, you know, being consolidated or merged or one of the other merged. We take findings on the case of that letter from Councilor Staff. Mr. Clerk, take this. When this case was called for hearing, qualification of representation. The court observed the access of the council to represent the appellant. And then the judge be first appellant.
Message here.
Yeah.
To power.
Connect the
Access of the council.
And of course, inquiry. Marshal, as for the marshal in the church, that the Dean and Associate law firm were allegedly served. But this court notes that as per a letter dated April 21, 2025 from the lesser value law practice and signed by Councilor E. Johnson Sally, suggests that it was this law firm that served as not Dean and Associate law firm, which was the law firm representing the party in the trial court up to the level of the justice in chambers, who is doing how to review. What will follow into the issue is what says that it will accept the letter of the legislative law partners point this court for offering court to proceed to issue of assignment and with the aid of graduate law partners. Endeavor to serve the party itself. Serve the party that is the appellate itself. This matter is therefore referred to as the date of what regular notice of assignment. What regular notice of assignment. It is hereby so ordered. As a benefit.
Legislature formats, representative meeting with the speaker, representative respondents, with recommendations of
all lawyers representing the parties, if all lawyers representing the parties, as per precedent, those absent lawyers are hereby fined the amount of 500 United States dollars. Thank you, Mr. Clerk. If we are dying, let's go on and finish all our time. If this court is decided to come, if no lawyer is here, that fine is enforced.
To our viewers, we are very, very sorry. The sound is low due to electricity issue here at the chambers of the Supreme Court of Liberia, and we are sitting a bit distance from the Chief Justice and Associate Justices of the Republic of Liberia.
Mr. Clerk, the Chief Justice will deliver the opinion on behalf of the bench. The law and politics are intrinsically interconnected. The former, that is the law, being the tool with binding effect, and the latter, politics, being the activity associated with the governance of the state that rely on the usage of the law to achieve its objectives. This relationship for the purpose of properly governing the state is clearly articulated under Article 2 of the 1986 Constitution of Liberia, which states, and I quote, "The Constitution is the supreme and fundamental law of Liberia, and its provisions shall have binding force and effect on all authorities and persons throughout the Republic." Unquote. The Constitution, as the supreme and fundamental law of Liberia, is the tool by which the state is structured and governed, and still confirms the intrinsic relationship existing between law and politics, and verify that the law is indeed the creator and foundation of politics. When adherence to the rule of law intertwines with political processes, a rare but not unprecedented controversy may arise, one so powerful that its legality reverberates through the very fabric of the nation. Such is the scenario in the present amended Bill of Information and the in proceedings from which it emanates. This amended Bill of Information under review, which finds its genesis, as already stated in the case, in reading the constitutionality of certain actions taken by some members of the House of Representatives of the 55th Legislature, Supreme Court Opinion, October 3rd, 2024, exemplifies the delicate nature between statutes, codes, and bodies where the issue is not merely one of legal precedence, but one that strikes the core of respect for and adherence to the rule of law. Its consequences extend beyond the courts, reverberating into the essence of the fabric of our society and the citizenry. As the Supreme Court renders its opinion and judgment, it is confronted not only with the letter of the law, the court's independence and fearlessness, but also with the weight of public trust. In this moment, justice must be seen not only through the lens of legal text, but as a reflection of the people's spirit, for, and I quote, all power is inherent in the people, and all free governments are instituted by their authority and for their benefit, unquote. Constitution of Liberia, Article 186. This is a time when the law's blindness to the transient whims of politics reaches its zenith, but at the same time, this endearing consideration to the enduring cause of national interest becomes a paramount concern. The present amended Bill of Information filed by quote, Speaker J. Funati Kofa and members of the House of Representatives of the 55th Legislature, the informants herein, alleges that, quote, Speaker Richard N. Poon, unquote, Deputy Speaker Thomas Fowler, and members of the self-styled, quote, majority bloc, unquote, of the House of Representatives, also of the 55th Legislature, the respondents hearing deliberately violated and continue to perpetuate said violation of the final judgment and mandate of the Supreme Court rendered on December 6, 2024, in the opinion in reading the constitutionality of certain actions taken by some members of the House of Representatives of the 55th Legislature. Just pause.
So folks, LDC, I guess, and we apologize for the poor sound quality, and in any moment from now, the regular sound, because this is the Liberia National Television.
Everything okay? All right, we will continue. The records show that the informants first filed a Bill of Information on December 12, 2024, but subsequently withdrew saying and refiled an amended Bill of Information in its stead on March 5, 2025. Hence, by established legal principles and procedures, the refiled amended Bill of Information is the one for the court's consideration. The crux of the amended Bill of Information are set forth in counts 1.2 and 1.3 thereof, and for the purpose of expediency and relevancy, we quote verbatim the said counts as follows. Quote 1.2. In the ruling, the court held that whether a simple majority is sitting or a lower number, in both cases, a presiding officer defined in Article 49 of the Constitution as the Speaker, and in his or her absence, the Deputy Speaker must preside. And in the final judgment, your honors held that any sittings or actions by members of the legislature not in conformity with the intent of Articles 33 and 49 of the Constitution are ultra vires. Hence, members of the House of Representatives are to conduct themselves accordingly. The clerk of this court is hereby ordered to inform the parties, and it is hereby so ordered. Count 1.3, still quoting the amended Bill of Information. In the ruling, your honors held and determined that the sittings, decisions, and actions that the self-styled majority bloc previously took were ultra vires, i.e., unauthorized and therefore illegal. This included the unconstitutional removal of Speaker Kofa as Speaker and the purported election of Representative Kuhn as Speaker. In the court's final judgment, your honors ordered the members to conduct themselves in compliance with both the quorum provisions of Article 33 as well as Article 49, which required the presence of the Speaker as the constitutional presiding officer, unquote. The informants further cite in count 2.1 of the amended Bill of Information the actions which they believed amount to violation of the Supreme Court's mandate. We also quote the alleged violations as contained in count 2.1 as follows to wit. 2.1, quote, in deliberate and intentional violations and direct contravention of the court's ruling and final judgment, Representatives Kuhn and Fala and other members of the self-styled majority bloc have continued to convene and hold unauthorized hearings, including budget hearings, all of which were declared ultra vires and invalid in your honors ruling and final judgment, to wit, A, voting upon and passing into law the fiscal year 25 budget document without authorization, recklessly endangering the full faith and credit of the Republic of Liberia by purporting to legislate the primary fiscal instrument that drives the nation's economy and spending power when they knew or should have known they did not have the authority to do so. B, authorizing the withholding of salaries and legitimate benefits of certain members. C, authorizing the payment and disbursement to certain of its members for their personal benefits, financial resources belonging to the House of Representatives, or financial instruments belonging to non-members of the majority bloc. D, invading the premises of the office of the Speaker of the House by use of force without authorization or court order, and refusing to allow the Speaker of the House of Representatives to conduct business by seizing the instruments of governance of the House using force. And E, attempting to recall from their lawful assignment the members who are representatives to ECOWAS when they knew or should have known they had no legal right to do so, unquote. On March 14, 2025, the respondents filed the 36-count returns to the amended Bill of Information, denying therein any violation of the Supreme Court's opinion and judgment of December 6, 2024. In their 36-count returns, the respondents first proceeded to extensively refer to numerous portions contained in an opinion by the Attorney General, alluding to the December 6, 2024 opinion of the Supreme Court. These are found in count 1 and 9. Counts 1, 9, and 15, and 9 to 15, in fact, of the returns. This court notes that the referenced opinion by the Attorney General is not before the court and therefore will not burden its opinion by delving on sin. It is common knowledge, though, that one of the duties of the Attorney General as set forth in the new executive law is to furnish opinions as to legal matters and to render services requiring legal skills to the President and other agencies of the executive branch of the government. Howbeit, it must be noted that the said opinion of the Attorney General do not change or affect the rulings and or opinions of the Supreme Court or subordinate courts, and any opinion given in that regard is of no relevance to the opinion and judgment of this court. We therefore proceed and quote below what we have determined as pertinent counts of the respondents' 36 count returns. And those are count 6, count 7, count 17, count 18, count 19, count 20, count 22, count 29, and count up to from 33 up to the wherefore. And this is in the prayer. Wherefore, and in view of the foregoing, respondents pray your honors to declare, that respondents have not violated the order or mandate of your honors, opinion, and judgment of December 6, 2024, captioned in read the constitutionality company judgment, except of which we quote below. 1. That is, court's interpretation of Article 33 of the Constitution 1986 is that whether a simple majority is sitting or a lower number, in both cases, a presiding officer defined in Article 49 of the Constitution is the Speaker, and in his or her absence, the Deputy Speaker. 2. That in the event where the Speaker is presiding over a minority, the Constitution is devoid of the mechanism for how the minority is to compel attendance of a majority who choose not to attend session. And the legislature has promulgated no enabling statute or standing rules setting forth the process for compelling absentee members to attend sessions as envisioned under Article 33 of the Constitution. 3. That was the wherefore portion of our 2024 ruling. Wherefore, in view of the foregoing, any sittings or actions by members of the legislature not in conformity with the intent of Articles 33 and 49 of the Constitution are ultra-virus. Hence, members of the House of Representatives are to conduct themselves accordingly, unquote. It is obvious that notwithstanding this court's declaration in repetition as to what the law is and what adherence thereto is required of the then petitioners, now informants, as well as the respondents thereto, who are also the respondents herein. Each party has ascribed differing interpretation to this court's opinion and judgment. These differing views are the bedrock of this amended Bill of Information, as the respondent have prayed as the respondent respondents have prayed in count 33 of its returns to the Bill of Information that this court must be definitive and exact in its disposition of the amended Bill of Information, so that its ruling of December 6, 2024 will not be susceptible to more than one interpretation, since the informants using their interpretation of the court's opinion of December 6, 2024 has caused continuous disruptions and interruptions at the House of Representatives with the sole aim of making the House of Representatives dysfunctional. This view by the respondents therefore requires the court not only to revert to the opinion from which these proceedings emanate, but to provide clarity and remove all cloud of uncertainties, if any, as to this court's opinion and judgment in the petition, to obviate any future misinterpretation thereof. In executing this task, we are reminded, as we stated supra in this opinion, that the Supreme Court, in making a determination of this amended Bill of Information, is not only confronted with the letter of the law, but also that those actions violated Articles 28, 33, and 49 of the 1986 Constitution, which address due process, quorum, the designation of the Speaker as the presiding officer, and related provisions. as well as Rules 10 and 48 of the Rules and Procedures adopted by the House of Representatives of the 55th Legislature. In his returns filed on November 26, 2024, Representative Richard Nagwe Poon, designating himself as Speaker on behalf of those representatives supporting his position, prayed this Honorable Court to deny the in-re petition filed by Councillor J. Fonati Kofa, Speaker of the House of Representatives and representatives of the 5th Legislature. Representative Poon asserted the following: that the removal of Honorable J. Fonati Kofa, Edward Flomo, Abu Kamara, and Marvin Cole from their respective positions in the House was a purely political matter and not justiciable before the Supreme Court. That consistent with prior opinions, the Supreme Court has refrained from addressing political questions. That consistent with prior opinions, the Supreme Court has refrained from addressing political questions. That the Constitution grants the House of Representatives the authority to promulgate rules, hold quorum, and expel its members under rules adopted by the House. That all individuals listed in the in-re petition were accorded due process of law and were subsequently removed for violating the rules of the House of Representatives. That Councillor J. Fonati Kofa was removed based on charges of corruption and unethical conduct. That Edward Flomo, Abu Kamara, and Marvin Cole were removed on charges of unethical conduct that impeded the work of the House of Representatives, and that under the doctrine of separation of powers, the Supreme Court cannot review the decision of the House of Representatives to remove its members who were investigated and found in breach of the House's rules. Upon review of the various contentions advanced by the respective parties in the in-re petition, this court noted the following pertinent issues for consideration. 1. The jurisdiction of the Supreme Court to adjudicate issues arising from such internal disputes among House members was explicitly challenged. And 2. That both parties sought the interpretation of Articles 33 and 49 of the Constitution to support their respective actions and or sides. In our determination of the issues advanced by the parties in the in-re petition, this court opined as follows. 1. As to the Supreme Court's authority to adjudicate cases arising from internal disputes among members of the House of Representatives, this court opined, and I quote, predicated upon its authority articulated in Article 66 of the Constitution, the Supreme Court does have jurisdiction to decide allegations of violation of the constitutional rights of members of the legislature, even if arising out of internal wrangling among the members of the House of Representatives, as seen clearly falls within the purview of Article 66 of the Constitution. Unquote. In this regard, the Supreme Court noted that although the petition filed by Speaker Kofa involved an internal dispute within the House of Representatives between Councillor J. Fonati Kofa and certain members on one side and Representative Richard N. Poon and other members on the other side, the crux of the dispute between the parties poses a constitutional crisis, thus vesting the Supreme Court with the authority to delve into sin. Accordingly, we herewith reaffirm this position of the court as was done in the December 6, 2024 opinion. This court emphatically declares that it is within the power and authority of the Supreme Court of Liberia to say what the law is without fear or favor, irrespective of the parties before the court. That pursuant to this constitutional authority, the Supreme Court can and will address any allegation of a constitutional violation within any branch of the government. 2. As to the interpretation of Articles 33 and 49 of the Constitution, this court unequivocally held that, and I quote, a simple majority of each house shall constitute a quorum for the transaction of business, that whether a simple majority is sitting or lower number, in both cases, the presiding officer defined in Article 49 of the Constitution is the Speaker, and in this case, Speaker J. Funati Kofa, who was duly elected, presides over the House's functions except absent or removed as required under Article 49 of the Constitution and the rules of the House of Representatives, that is rules 9, 8, 9, and 10. The Supreme Court has consistently held that in interpreting the provisions of the Constitution, statute, or all provisions or sections relating to the same subject or provisions having the same general purpose to be construed together as though they constituted one law or one provision, and that they must be construed, governed by one system, one spirit, and policy. Predicated on this principle of law, the Supreme Court interpreted Articles 33 and 49 together, giving that each provision complements the other. In application to Speaker Kofa as regards these two provisions, we opine and held that, and do hold now, that although Speaker Kofa, who at the time was presiding over a minority membership of the House of Representatives, and as such could not Rule 21 of the House of Representatives and penalize absentees in a manner deemed appropriate, as saying had to be done in consultation with plenary, which requires a quorum, and he not being able to form a quorum for plenary as the absentees comprised the majority of members of the House. The Constitution, statute, and rule and House rules are all silent as to how the minority is to compel attendance of absentee members who insist on being absent. We therefore are at a loss. We are therefore at a loss, as there is no enabling statute, promulgated or standing rules setting forth the process for compelling said absentee members to attend sessions as envisioned under Article 33 of the Constitution. Also, in application to the respondents, this court noted and notes even now that in addition to Articles 33, Rule 7, 7.2, 8, 8.1 and 12 of the House of Representatives of the rules of the House of Representatives provide that, and I quote, a quorum shall consist of simple majority of the members of the Honorable House of Representatives, which shall be necessary for the transaction of business. However, a minority may meet from day to day. Meetings at which a quorum is not present, only a motion to compel the attendance of absent members or to adjourn may be made, unquote. Therefore, even though the respondents comprised of a simple majority, it was not only necessary but constitutionally mandatory for said quorum to be presided over by the presiding officer defined under Article 49 of the Constitution as the Speaker, that is Speaker Kofa, and only in his absence the Deputy Speaker. Having expounded on this court's decision in the in-re petition, we are now left to determine whether or not either of the parties pursued with this court's declaration of December 6, 2024. As we stated supra, the informants listed a number of actions which they alleged amount to violations of this court mandate in the in-re petition. Beginning with the informants, we emphasize that we see no promulgation of an enabling statute as to how Article 33 of the Constitution of Liberia can be executed by the presiding officer, whom we have held pursuant to Article 49 of the Constitution is the Speaker, that is Speaker Kofa. And unfortunately, he has presented no means as to how he, the constitutional presiding officer of the House of Representatives, can compel absentee members to attend a session for the purpose of obtaining quorum for the transaction of business. What is before us is this amended bill of information, an amplification of this dilemma, which we stated in the court's previous opinion of December 6, 2024, when we declared that setting a sanction to compel attendance by the simple majority was without the ambit of the court, as this Supreme Court does not make laws. Besides, it would be in violation of the Constitution on separation of powers. In a situation such as this, where a majority of the members of the House of Representatives refuse to sit under their elected Speaker or to have him removed as the Constitution dictates, this court can only speak to said violation as being in total disregard to the law which members of the House of Representatives took an oath to uphold and protect. As to the respondents, we similarly ask the question, have you pursued this court's declaration of December 6, 2024, especially as we have espoused herein? It is common knowledge that the members of the House of Representatives are or have been conducting a parallel House with a minority group meeting and presided over by Speaker Kofa and a self-styled majority group of bloc These parallel sittings and or actions lack legal foundation either by the dictates of the Constitution or any other laws within this jurisdiction. Additionally, we take judicial cognizance that during the hearing and determination of the in-re petition, the respondents firmly argued, as stated in their returns, that they expressed a vote of no confidence in the leadership of Speaker Kofa, that their quorum in the joint chambers of the legislature was legitimate for the transaction of business since they met the constitutional requirement of a simple majority as prescribed in the Constitution and the rules of the House of Representatives, that their quorum was being chaired by a presiding officer in person of the Deputy Speaker who is legally clothed with the same authority as the Speaker to preside over their deliberations in the absence of the Speaker. And we emphasize absence while we paraphrasing what the respondent said in their return. During oral arguments before this court, one of the counsel representing the respondents was asked a question by the court as to the whereabouts of Speaker Kofa at the time Deputy Speaker Thomas Pala was acting as the presiding officer during the parallel plenary session in the joint chambers of the legislature. In response thereto, the respondents' counsel stated that Speaker Kofa was, and I quote, in another room, unquote, within the confines of the legislature. This response by the respondents' counsel raises the cardinal question of whether the Deputy Speaker or any other representative could legally preside over any plenary session, even if said session met the simple majority criteria for the transaction of business, and no action therefrom can be considered by this court as constitutional. Therefore, any action or sitting by the majority to the exclusion of the Speaker presiding while he is present and available to preside is unconstitutional and without the pale of the law, and we so hold. This court held in the case Bad Boy versus Jala and All Supreme Court opinion October 3rd, 2014 that, and I quote, the Constitution provides the framework within which the legislature operates, and any act, including a vote of no confidence that breaches constitutional provisions on due process shall be subject to judicial review, unquote. Moreover, the purported quorum which the respondents claim to have had to conduct official business of the House of Representatives was done in the joint chambers of the legislature, whereas the Speaker, who was available, which fact is conceded to obey the respondents in both their returns and oral arguments before the Supreme Court, was convening session in the plenary chambers, which is the official place for sitting for the plenary session for the House of Representatives to conduct official business. The resolution of this present crisis amongst the House of Representatives does not lie solely with the court to say what the law is, but adherence to the mandates and directives of the Constitution is devolved upon every citizen and all authorities within the country. Therefore, all authorities and officers of the state, whether the legislature, executive, or judiciary, or officers of government created by and exercising powers pursuant to the provisions of the Constitution, are expected to meticulously abide by all constitutional mandates and directives. This court in the case CPP versus NEC, Supreme Court opinion versus NEC, and the Honorable House of Representatives and the Executive Branch, Supreme Court opinion October 10, 2020 stated, and I quote, that constitutional mandates are absolute rules of action and decisions for those who are required to exercise them. Failure to abide by the mandate of the Constitution is repugnant to this supreme and paramount law, and said disregard for the constitutional mandates exposes the nation to lawlessness and pose the risk of undermining the democratic and law-abiding culture for which the Constitution was promulgated, unquote. Have been clarified our opinion and judgment. The further question of concern now is whether a bill of information will lie in the instant case. During arguments of the amended bill of information, one of the counsels for the informants strenuously argued that the respondents violated the mandate of this court by the commission or omission of actions enumerated in the amended bill of information. Therefore, the informant prayed that this court enforce its mandate contained in the December 6, 2024 opinion and judgment of the in-re petition. When he was also asked to say what the mandate of this court was in the in-re when he was also asked to say what the mandate of this court was in the in-re petition, he answered that the mandate is encapsulated in the concluding paragraph of our judgment, which reads as follows, quote, wherefore, and in view of the foregoing, any statements or actions by members of the legislature not in conformity with the intent of Articles 33 and 49 of the Constitution are authorized, unquote. On the other hand, and as earlier stated in his opinion, one of the counsels for the respondents, also relying on our judgment, argued that the respondents did not violate this court's mandate and therefore urged this court to be both definitive and exact in its disposition of this amended bill of information, so that its ruling of December 6, 2024 will not be susceptible to more than one interpretation, unquote. In a plethora of Supreme Court opinions, this court has unwaveringly and consistently recognized that only a bill of information can remove on such grounds their own personal interpretations of what the law is. It is imperative that in keeping with our precedent espoused in the aforementioned cases, it is necessary for the purpose of constitutional clarity and respect for the rule of law to grant this bill of information insofar as it relates to the parties' uncertainty of the December 6, 2024 opinion and judgment of the court. Wherefore, and in view of the foregoing, the bill of information is granted for the reasons stated herein, and the quote majority block unquote are hereby mandated to operate in accordance with the Supreme Court's interpretation of Articles 33 and 49 of the Constitution as contained in the court's opinion and judgment of December 6, 2024, and further clarified in this opinion. The clerk of this court is hereby ordered to inform the parties of this court's decision, and it is hereby so ordered.
So folks, you listen to the Chief Justice of the Supreme Court of Liberia reading the final ruling of the bill of information filed by members of the minority bloc held by embattled Speaker Funatik Kufa, reaffirming December 6, 2024, calling on members
on the fundamental principles of law, we shall be here at all times. I am in disagreement with my esteemed colleagues who opine that the amended bill of information rely on Rule 4 by 12 of the revised rules of the Supreme Court. From the onset, let me say that my position is that the contention asserted in this proceeding cannot be addressed by the Office of the Bill of Information, and that this case presents a clear political question which cannot be answered by the court. Under the doctrine of separation of power, the court cannot decide in case in which it is clear that the responsibility to make a co-decision which ought to put finality to the controversy and enforce solely.
Please, that door should not be open at this time. Nobody leaves the court and nobody comes in. A justice is really sent here. We are not through yet. Mr. Marshall, please.
Force solely on the legislative or executive branch of government. The question of the constitutionality of action taken by certain members of the House of Representatives has again appeared before this court. They shall by a bill of information, later withdrawn, and it placed for an amended bill of information. Since I'm having agreement with the narrative, let me just go to my contention. From the above 5 and 7 stage, the prime issues that claim my attention are 1. The Office of Bill of Information in our jurisdiction. 2. The action of the majority bloc in passing the fiscal budget of 2025, which was subsequently confirmed by the Liberian Senate. And 3. The functioning and operation of the Liberian government under the approved budget of 2025. I shall discuss the issue in the order presented. But before proceeding, I wish to make the following observations. First, the controversy in the House of Representatives is more of a political matter, especially as it relates to the means of compelling one block of the House to attend a session where the Speaker is the presiding officer. As we stated in our last judgment, neither the Constitution of 1980 it said now the rules of the House of Representatives set a procedure for compelling members who fail to attend the session. This court, as it has stated, cannot intervene by setting the procedure for the House of Representatives, which will amount to a violation of the Constitution of the 3 branches of government under Article 3. Second, the role of the court is to pronounce what the law is through a judicial function of interpreting the law in each case. In the current controversy, this court was clear by declaring that any setting of the legislation not consistent with the intent of Article 33 and for the court is ultra-virus. The responsibility to adhere to the provision of the 2 articles rests with the House of Representatives, who are lawmakers and who should know that the Constitution is the supreme law of this country and its provision are binding on authorities, including the legislature, Article 2. Moreover, the legislature under Article 21 of the Constitution took a solemn oath to uphold and defend the Constitution and the laws of the Republic. Thus, their action must be consistent with the oath they took. The other observation I make is that our government under Article 3 of the Constitution consists of 3 separate branches. 3 separate coordinate branches, in my opinion, speak to the relationship between the three branches for the effective and efficient running of the government to preserve law and order and maintain peaceful coexistence. If one branch fails this responsibility by ignoring the Constitution and the laws of Liberia, that is pushing the country into a dangerous territories and unhealthy for our nation. My final observation is that the House of Representatives has placed itself in the power struggle motivated by politics. We this court should be cautious not to be in the center of such a country. But the duty of the court, as I said, is to state the law. They say what the law is and not engage in political dispute as it is in the instant case. The first issue I have identified is the Office of the Bill of Information. Public directly whether the Bill of Information will lie in the instant case. I answer in the negative. Rule 4, Part 12 of the revised rules of the Supreme Court of Liberia prescribe the Office of Bill of Information as follows. Quotation open. The Bill of Information will lie to prevent a judge or judicial officer who attempt to exclude the mandate of the Supreme Court, who attempt to execute the mandate of the Supreme Court in an improper manner from doing so with the judgment and or mandate of the Supreme Court. B. The Bill of Information will also lie to prevent anyone whosoever from interfering with the judgment and or mandate of the Supreme Court. Quotation question. From the above rule, it is profoundly clear that the Bill of Information in this jurisdiction, in its legal context and application, is an exclusory proceeding that complains of the judge or judicial officer who attempts to execute the mandate of the Supreme Court in an improper manner, or any person who interferes with the mandate of the Supreme Court. In other words, a Bill of Information may be brought and give a judge, the judicial officer, or any person whosoever who are contrary to the mandate of the Supreme Court by disobeying, interfering, or obstructing the mandate of the Supreme Court. In consideration of the above rule, I ask what the mandate and the judgment of the Supreme Court of December 6, 2024 constitute a mandate, order, or instruction to anyone? The answer definitely is no. The mandate is essentially an official order or instruction. In the legal context, it is a document that emanates from the higher court to the lower court that tells the lower court what to do next after a decision has been made by the appellate court. The mandate is a formal order from an appellate court to a lower court, notifying the lower court of an appellate court decision and directing the lower court to act accordingly. Black law dictionary definition. In the application of the definition above put there are two things that stands out: an order or instruction from the appellate court, and the lower court is directed to do an act. In my mind, there is no mandate from the Supreme Court to the lower court in the December 6, 2024 judgment. This is the case involving controversy between members of the House of Representatives and the court. And the court was called upon to interpret the law, specifically Article 3 and 4, relevant to the action of the members of the House of Representatives. This court, being mindful of the constitutional crisis that would have arisen, had issued a mandate to the members of the legislature refrain from doing so, and by the way, would the Supreme Court instruct the members of the House of Representatives to stop voting session, be it minority or majority. Secondly, that such a mandate be sent to the members of the House of Representatives and not obey, the Supreme Court would have created a risk and the crisis that will challenge its authority. In other words, the Supreme Court cannot legally hold the members of the House of Representatives in contempt for disobeying the order of this court. Because involvement of a contempt against members against another branch of government will create a legal storm of uncertainty. Of course, of a recourse to the judgment of the Supreme Court, the relevant part thereof is quoted below to address the issue of the mandate. Hence, members of the House of Representatives are to conduct themselves accordingly. The clerk of this court is hereby ordered to inform the party and it is hereby so ordered. Secondly, there is nothing in this statement that constitutes a mandate from the Supreme Court. The only order here is given to the clerk. And the only thing the clerk is required to do is to inform the parties. The mandate of this court has always been declared directly to the lower court to do an act specified therein. The Supreme Court, in giving a mandate, does not inform the lower court. It rests. Hence, the Supreme Court orders the clerk of court to inform the parties of its judgment without any instruction or directly to the parties. More besides, the prayer of the current informant really does judicial cooking. Thereby, pray to declare the action of the proposed Speaker Kun and members of the majority ground not involved at the issue and session hearing decision that violate the court's ruling and final judgment order barren and unconstitutional. The question my only choose to know is how can the Bill of Information act to declare action unconstitutional when a Bill of Information is supposed to be ordered? In the Bill of Information, the prayer can never legally be a request to declare an action or to declare an act of action unconstitutional act and illegal as contained in the current informal prayer quoted above. The prayer for a Bill of Information is to punish the respondent for violation of all disobedience or the court mandate. But on the contrary, as quoted above, the informant herein asked the court to re-declare unconstitutional or utter what the court had earlier declared in 8 December 2024 opinion. And unfortunately, majority police proceeded to re-declare, re-clarify, and explain the judgment of December 2024, contrary to Rule 4, Part 12 of the Supreme Court. This is not and has never been the office of the Bill of Information. It is an unequivocal departure from the rule of the Supreme Court. The action by my esteemed colleague has created a Pandora's box and leave many questions the answer, wherein anyone who is dissatisfied with the Supreme Court opinion in the vision will revert to the Supreme Court via a Bill of Information to explain, declare, and restate the court judgment. This is held in the history of this court. I am of the strong conviction that whether right or wrong, the informal Bill of Information came to this court through an improper manner or in a library pattern through a back door, and therefore unacceptable in the case of Rule 5, Part 12 of the current Supreme Court rule. This court cannot and should not encourage a party litigant to pursue what may be their right through a wrong path, as two wrong cannot make it right. My majority colleague cannot disagree with me that the petition for a re-constitutionality is a declaratory judgment, because it prays for a request to the court to declare certain act or law unconstitutional. So when such act or law is declared by the court, any party who feels strongly that the right declared by the court has been violated has the right to proceed to the appropriate tribunal to establish and prove who violated his rights, where they were violated, when they were violated, how they were violated, etc. All of which are facts of matter that require evidence taking, which the Supreme Court is prohibited by law likely. Secondly, these facts cannot be established by a Bill of Information before the Supreme Court. As recent as 2020, in the case Equal Ben for Investment and Development versus United Commonwealth Incorporated, a declared judgment was filed in several courts, and the losing party prayed for a plea to the Supreme Court. The Supreme Court having heard the plea, amended on the several court to resume jurisdiction and impose the payment of the money judgment. That mandate of the Supreme Court was challenged through a bit of information, and this court was compelled to concede and will consider the signing of the bit of information and rule reverse itself and send order below for the party who right was declared to file an appropriate action. Accordingly, the appropriate action was filed, and as we speak, the trial is proceeding before the proper court below. It is unfortunate that my majority colleagues, as recent as 2020, are pursuing the same error. I conclude that there has been no mandate from the Supreme Court. The bill of information does not meet the requirement or Rule 5 Part 12 of the revised rules of the Supreme Court and the law. Hence, the opinion and judgment of my majority colleague is a slap in the face of justice. In my opinion, the judgment of my esteemed colleague is unfortunate and it is a miscarriage of the law. Now coming to the second issue, whether the passage into law of the budget of the fiscal year 2025 by the majority block of the House of Representatives and subsequently confirmed by the Liberia Senate is legal as made by the informer. In addressing this issue, I must consider the political and legal act and experience under the circumstances of this case. Though an impasse exists in the House of Representatives that has divided them into so-called majority and minority block, they still have the right to sit in spite of the Supreme Court decision for December 2024. As earlier indicated in this opinion, the Supreme Court has no authority whatsoever to stop another branch of government from performing its constitutional duty. The majority bloc was sitting received a draft budget from the draft budget for the fiscal year 2025 from the clerk of the House of Representatives, which was submitted by the President of Liberia. The majority bloc deliberated on the draft budget and passed it, then submitted it to the Liberian Senate, which concurred by confirming the act of the majority bloc with respect to the passage of the budget. Here a political decision was made by the majority bloc and the House of Senate by taking action to pass on the draft budget. Now we're saying the impact at the House of Representatives. Following this political decision, the majority bloc and the majority bloc and confirmed by the Liberian Senate, the budget was submitted to the President of Liberia to sign, which he did in line with his official duty as President of the Republic of Liberia, head of government and chief executive of Liberia. The experience of these actions cannot go unnoticed by any reasonable man, and this court is not unaware to what you have enlarged into an eminent peer in the government of Liberia. And recently, the circumstances that would have led to a peer and total collapse of the government of Liberia. The President of Liberia, in keeping with his constitutional duty as the head of state and chief executive, is required to submit a draft budget for each fiscal year to ensure the operation of the Liberian government, pay salary, pay obligation of the government, and provide operational expenses for the three branches of government. And by law, the fiscal budget for 2025 should have been submitted to the House of Representatives before October 10, 2024. What then would the President have done in the midst of the divided members of the House of Representatives? Wait until the government collapsed because the fiscal budget had not been passed. Indeed, that would have been an unmanful act or non-functional government to head. In his position as President, head of state and chief executive, he proceeded to submit the draft budget to the clerk of the House of Representatives, which the majority bloc took cease of. As I recall, at the time the Supreme Court rendered its decision on December 2024, the President was nearly late by 2 months to comply with the budget law. Giving order to the above circumstances, the executive branch of government of Liberia acted promptly and politically by signing into law the budget that has been passed by the majority bloc of the House of Representatives and the Liberian Senate for the survival of the state history. Thus, this is now the 2025 fiscal budget which this government is utilizing to operate, which every branch of government is drawing on. Moreover, the act of the executive in practicing the 2025 fiscal budget, irrespective of the legislative power, is in line with the concept of self-preservation of state. This doctrine of international law refers to a state fundamental need to protect itself, to protect itself, its citizens, and its interests from harm or destruction, often in the face of the standard threat or internal instability. The executive action also finds support in public policy. As head of government, head of state, head of the government, and commander-in-chief of the armed forces of Liberia, advocacy, the president exercised expediency and approval power under Article 35. And as a consequence of this, he signed the budget into law after the usual concurrence granted by the Honorable House of Senate. Moreover, in the action of the resolution, the solution to the legislative problem, the President could not wait for the state machinery to run to halt because of the dialogue at the House. This would have certainly had security implications and other implications wherein the entire functionary of the government would lack due to lack of operating budget to keep health facilities, school facilities, and other functionaries of the government, including the judiciary, from performing its duties and functions. I now come to the third and final issue, the functioning and operation of the government under the budget of 2025. The question is made the majority block of the House of Representatives or any branch of the Liberian government receive benefit under the same budget and then challenge it legally and answer no. I also answer in the negative. In the case that would be the operating company was the ASA, Edion, the 1 era, 49, 1983. Number one who knowingly accept the benefit of the contract or conveying the escape from denying the validity or banning effect on him of such a contract or conveying. There will be an inconsistent position to benefit from the budget of 2025 by receiving salary and then seek to challenge its legality. This brings to mind the majority black position that the budget has passed is illegal. Then they cry out that they have been denied salary for which they resorted to the Madam proceeding before this vote. The question then is under which budget they seek to recover their salary. Are they seeking salary under the same illegal budget of the 2025 declared illegal? In my mind, this amounts to a contradictory position which I cannot sustain. Expanding this question further, may any branch of the government seek to benefit from the budget of 2025 and then declare saying illegal? And this question is more to be considered by this court. Secondly, currently the Liberian Judicial, like the other two branches of government, is receiving salary benefits and operational expenses under the 2025 budget. In the wisdom of the court, could it declare the budget illegal? I think which so is preposterous, because the consequence will be producing chaos and collapse of the government for lack of money to operate, and the judicial will be paralyzed. The court is clarified and should be reasoning in applying the law in the light of the 7th century of a particular case as stated instantly. The preservation of our government, maintenance of security, peace, and orderliness in our society are embodiment in the judicial pronouncement of what the law is. Hence, the action of the President as head of state, head of government, and commander-in-chief of the armed forces for Liberia to prevent here, which would have made us to sit here today as justices, far supporting law, experiencing public policy. As the prime duty of the constitutional code is to interpret the law for the safety and survival of the state. For these stated reasons above, I respectfully will hold my signature from the majority opinion of this court as based on information will not legally lie. I further hope and pray that the opinion of the majority will be recalled in the sooner immediate future. And respectfully so.
Yes, Assistant Justice Yamin Kofi reading his dissenting opinion
For this case, we call
information found by
Arthur T. Johnson, Jonathan T. Massimo, and Dasha T. Fakel appear for informants. Councilor H. Fani G. Sherman and our esteemed appear for respondents. Having carefully examined the contentions and parties, listen to the arguments on both sides, and consider the laws relevant therefore to the share that the Bill of Information will allow to clarify uncertainties in opinions and judgments of the Supreme Court. In the instant case, the parties being at variance with respect to what constitutes the December 6, 2024 opinion and judgment of this court, the amended Bill of Information is proper for such clarification, and at the conclusion of the Supreme Court opinion and judgment of December 6, 2024 is that any sitting or action by the quote-unquote majority black, in quotation, in parentheses, respondents to the exclusion of Speaker J. Fonati Kofa, the duly elected presiding officer of the House of Representatives, while he is present and available to preside, is unconstitutional and without repeal of the law. Wherefore, in the foregoing, the amended Bill of Information is granted for the reasons stated in the opinion of this judgment in the quote-unquote majority black, in parentheses, respondents, is hereby mandated to operate in accordance with the Supreme Court's interpretation of Articles 33 and 49 of the Constitution as contained in the Court's opinion and judgment of December 6, 2024, and further clarify the opinion of this judgment. The clerk of this court is hereby ordered to inform the parties of this court's decision, and it is hereby so ordered. Giving under our hands and the seal of the Supreme Court of Liberia this 23rd day of April, 2025. Signed, Senyinji, your Chief Justice, Supreme Court of Liberia. Chintleta Hawa Wodokoli, Associate Justice, Supreme Court of Liberia. Yusuf B. Kala, Associate Justice, Supreme Court of Liberia. Senyinji Clement Johnson, Associate Justice, Supreme Court of Liberia. Lord, Mr. Justice Yami Gokulbaise, Senior, having dissented, do not sign this judgment.
So, folks, this is the Liberia National Television.
Mr. Chaplain, kindly close us in prayer.
The Lord be with you. Let us pray, Lord, we thank you
Supreme Court of Liberia.
for the
any moment from now, we are moving downstairs to speak with lawyer representing both.
Thank you, Lord. In Jesus' name we pray.
To speak with.
Mr. Deputy Marshal, this court will adjourn now to meet tomorrow morning at 11 a.m.
Honorable Supreme Court of the Republic of Liberia, sitting in 8 March 2025, now adjourned to meet tomorrow morning at 11 a.m. God save the Republic. It is honorable. The honors are the honor, actually the honor. Join this section to meet tomorrow morning at 11 a.m.
Thank you. Well, I think the ruling today more solidifies the acceptance of the Supreme Court in the minds and the sentiments of the Liberian. Because this ruling today, functionally and fundamentally, if you can read it, it more solidifies the name and the acceptance of the Supreme Court in the minds of the Liberian. Because the hope of the Liberian people was the Supreme Court. And that the clarity with respect to the interpretation of the law was functionally important for this particular case today. Now that the clarity is made by the Honorable the Supreme Court, and that it had specifically clarified, that Councillor J. Fonati Koba is the legitimate speaker, and that all actions taken by the majority black, headed by Rachel Coon, are considered unconstitutional. This time they have not used the word ultimate virus that was misinterpreted, because many of our people don't understand that the word ultimate virus is a Latin word, okay, and it also means illegal and unconstitutional. But the fact that the Supreme Court had associatively and definitively defined and said their action is unconstitutional, it cost the case.
Now, Council, you have five associate justices.
Yeah.
You have justices that have a discerning view and listed issues that are raised, saying that bit of information filed by the so what do you mean by that?
It is a right of an associate justice to dissent. It's the practice in our jurisprudence all over. Dissenting opinion has no effect on the majority opinion. The majority opinion is the law. And so the fact that 4 justices of the Supreme Court, including the Chief Justice, to agree that the actions taken, the suspension, the passage of budget, the suspension of members, the attempt to remove members from the ECOWAS, all of those acts are unconstitutional, that have been approved by the 4 members of the bench. That is the decision of the court. And in fact, that is why the Supreme Court said they will now go and force each of the branches to say, don't follow the opinion of, let's say, follow the opinion. But the fact that every one of them took an oath of the Constitution to respect the executive is duty bound by law and constitution and the oath that they have taken to respect the opinion of the court.
So you are not troubled about associate justice at the Senate opinion.
The dissenting opinion is his right. But let's look at the opinion. The dissenting opinion actually is the right of the associate justice to dissent, to disagree. That is the beauty of the practice of the law. But in any way, it's not an opinion of the court. Yeah.
Council, we have two quotes of opinion, one from the citizens and one of the Supreme Court. So in your mind, what if the executive decide not to do business with your client who is potent to be the legitimate speaker?
The first thing in history, we hold the executive responsible for disrespecting the law. One who is elected that violates the Constitution, that person his action is tantamount to impeachment. When you violate the Constitution, I don't believe that the executive branch will disrespect the opinion of the Supreme Court.
What is the move of the clan as we speak?
So what next for your clan, Johnson? What next?
Fonati Koba remains the Speaker of the House of Representatives. Fonati Koba resumes and maintains his authority as Speaker of the House of Representatives undermines the democracy and the pillars of our democracy. And it is now the time for them to set it right, because history has a tendency of judging people for violating the law, for disrespecting the rule of law. Because when the rule of law is broken, we have chaos. The only thing that oils the machinery of our social intercourse is the rule of law. And so it's left with him, and he is under obligation. And I don't also believe that Rachel Kuhn would disrespect the opinion of the Supreme Court. Thank you so much.
Initially this morning we told our listeners and viewers that we were going up to the Supreme Court to hear the ruling of the Bill of Information that was filed by lawyers representing Councillor Fanatic Kofa. And there the court actually ruled that the setting of the majority block was illegal, and Fanatic Kofa is a legitimate speaker. What they did was illegally done. But remember, among the associate justices, we had one that had a discerning opinion, meaning that we have one associate justice who did not agree with the police on several grounds and several reasons. And that person was Associate Justice Yami Bese. In his discerning opinion, he raised several issues, and he talked about the budget. And he mentioned that if Rachel Kuhn was a legal speaker, why did the judiciary go and defend the budget? He even talked about the Bill of Information, saying in his mind as an Associate Justice, it was the back door they took. It wasn't the right way they went about with the Bill of Information. And he said the police rendering such a decision in majority prosperity would judge them, because that would be a record that people will have. But the lawyer that represented Councillor Fanatic Kofa, who happens to be the lead lawyer, Councillor Arthur Johnson, who spoke to him few minutes, and he told us that he was satisfied with the ruling, to the extent that this was amended from the Supreme Court, and whoever the self-styled majority bloc should abide with them. So in the court of public opinions, there are so many questions being raised, especially from the court and even the grounds of the Temple of Justice, as to whether the majority bloc were aligned with Fanatic Kofa, who the court were in favor of. That's a question that is yet to be answered until we can wait to see what next is going to happen to the Capitol building right across the Temple of Justice.
Fabian, just one question. With this ruling, is this an affirmation of December 6, 2024?
If you go back to the video and watch it keenly and listen to the Chief Justice, you will see that at a point in time she kept mentioning about the December 6 ruling and saying that they reaffirmed and affirmed December 6 ruling. But again, I go back to Associate Justice Joseph, who had a discerning opinion saying that December 6 ruling was indefinite. They left it open and asked them to go and settle whatever they had at the house, at which time they mentioned ultra-virus. But this time around, the word ultra-virus was not mentioned. Instead, it was based on constitutionality. And so we wait to see what's going to happen at the house as to whether they will abide by the ruling from the Supreme Court, or it will be based on their own rules that they have at the house.
Thank you so much. Any final thing before we leave?
Well, I mean, the ruling has been done, and Liberians have been looking forward to whatever emanated from the Supreme Court. And the Supreme Court is the final arbiter of justice in our country. So we as citizens, maybe we will have to abide now, maybe because it's the law. And so in the court of public opinions, we have people disagree and agree. But whatever the case is, finally the Supreme Court has ruled the Bill of Information, reaffirming the legitimacy of Councillor Fanatic Kofa as a legitimate speaker, the 55th Speaker of the House of Representatives.
Thank you so much, Fabi.